When is probate required? And how long does it take? Probate is required when an individual dies with a last will and testament already in place. In legal terms, it's called dying testate. When an individual dies testate in New York and leaves assets that are not held jointly or in trust for, or don't otherwise pass by operation of law, it's required that a probate proceeding be commenced to prove that the last will and testament was validly created. What's the timeline for probate? The probate process begins with the appointment of an executor. The executor is a nominated person who is responsible for collecting the decedent's probate assets, paying any taxes or bills, and distributing the assets to the noted beneficiaries. Examples of probate assets include real property, such as the house, in the name of the decedent, checking account or brokerage accounts in name of decedent, cars, boats, stocks, bonds, and cash in the name of the decedent. It's important to note that assets that are jointly owned or in trust for are non-probate assets, and you do not need to collect them. Timeframes for appointment of an executor depend on the county in which the petition is being filed, and the appointment of the executor is signified by the receipt of letters testamentary. Once the executor has been appointed, then the executor begins the next stage of settling the estate. This is the process of collecting assets, paying bills, and ultimately distributing the assets. The overall estimated time frame for probate is around 10 to 20 months. However, this can be significantly expedited or hampered based upon your specific situation. A quick outlook is usually somewhere around 3 to 6 months, whereas a worst-case scenario could be many, many years. What elements of probate may take the longest? Without question, the greatest concerns and reasons for delay in probate are estate disputes. This is when one party either contests the will or believes that a fiduciary is mismanaging the estate. Examples include the following. 1. The will was not properly executed. For example, if the will writer did not adhere to statutory requirements, such as having proper witnesses and securing proper signatures. 2. The will was the product of undue influence. If there's speculation that the will was written under influence or pressure from some third party. 3. The will was procured by fraud. If the will wasn't actually written by the decedent in discussion. 4. The individual lacked capacity when executing the will. The second most harrowing probate matter is when you need to locate distributees who are nowhere to be found. To probate a will, you must locate all the next of kin. If they're easy to find, and perhaps you know them personally, then this is very simple. But if the next of kin are cousins, or you can't find them, or unknowns, then this can become a significant challenge. While this is still a hassle, rest assured, you do not have to go to any extreme measures, such as hiring a genealogist. Thankfully, pursuant to Court Rule 207-16D, you're only required to showcase that you gave your best effort to find the individual. Lastly, you may be tasked with finding mysterious objects or locating assets. As executor, it's your job to collect and care for estate assets, as well as settle any payments or debts. The general best practice in locating accounts and items are: speak to the decedent's accountant or financial advisor. They can provide pertinent documents such as tax returns or financial statements. Review bank statements as they come in. Speak with friends and family of the decedent. They may be able to provide leads or offer clues as to the organizational quirks of the decedent. Compile as much physical info as possible, such as mail, bills, and tax info. This information can provide you with next steps, such as contacting financial institutions. In general, if everything is easy, you can expect to find a few months tackling your responsibilities. However, if there are concerns with probate or your role in settling the estate, then this can extend the process by many months or years. Our firm focuses on practically and efficiently probating the will and resolving issues that arise during the probate process. Please feel free to contact us at 917-261-4514 to discuss your needs. Thank you.